Hello, this is Matt on the Moon Family Said Dan channel. As you know, the SEC is not the only organization or person that's suing Ripple currently. There's a case that dates back over 5 years, and they're making many similar claims, actually. Though technically the case is less complex, they're alleging that Ripple sold XRP as unregistered securities, and the most recent effort was to get class certification so that things could move forward here. And they did. Unfortunately, they did. So bad news for Ripple. Here you can see a headline from the Crypto Basic. Pro XRP lawyer says investors' class certification against Ripple is bad news. Although there's diverse perspective on this, so it's not that everybody necessarily thinks that would be the end of the world or even necessarily that bad. But I'm going to share with you the latest update on this, and I have opinion from 4 attorneys within the XRP community. That would be attorney John Deaton, attorney Jeremy Hogan, attorney Bill Morgan, and attorney Fred Rispoli. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Damn it. So let's do a minimal amount of table setting here. Here's a headline from February 7th of this year. I remember covering it at the time. This is from the Crypto Basic. Deaton plans to fight claims that XRP is a security in Zakhanov v. Ripple case. That's the name of the case that dates back over half a decade. And so what that article's covering, just to kind of cut to the chase here, was this perspective, this analysis from James K. Filan, also attorney within the XRP community. So this is what he said back then. And I don't have anything from him on the latest developments here, but I'm just covering this to set the table here. And this is what he wrote on February 6th. John Deaton will be filing a motion to file an amicus brief in Zakhanov v. Ripple in California. There, the plaintiffs claim that Ripple sold XRP as an unregistered security. They are asking the court to certify a class of all XRP holders who purchased and now hold XRP or who sold XRP at a loss. The proposed class would include XRP holders worldwide, including the 75,890 XRP holders around the world who disagree with the plaintiffs in Zakhanov and say XRP is not a security. So folks, think about this, and this is just, it's the epitome of absurdity as far as I'm concerned. And I understand from a legal perspective this is just how it would work, but it does sound stupid, can't deny that. So you're talking about all of us XRP holders, the vast majority, close to 100% of us, against this concept that XRP is some sort of security issued by Ripple. Almost all of us, almost 100% disagree with this concept. But what he's noting here is that should this class be certified by a judge, that we'd all be included in that, potentially. At least us here in the United States. That's stupid as hell, but that's the way the law works. It's the way the law works. And then Attorney Filan says, also, the proposed class is not limited to direct sales by Ripple and includes all sales of XRP, including secondary sales and international sales in countries where XRP has already been determined not to be a security. John Deaton will argue, among other things, that the court should not certify the class because of these conflicts and because there is only a small number of XRP holders who claim XRP is an unregistered security, while so many XRP holders worldwide claim it's not. John Deaton will argue that those small number of plaintiffs in Zakhanov cannot fairly represent so many who disagree with them, including XRP holders in places where XRP is not even considered a security. Spot on. And by the way, I'm going to share this tweet too. It was from February 6th because I thought it was funny. I remember covering it at the time. This comes from attorney Fred Rispoli, who responded to that thread I just shared with you. And attorney Rispoli wrote on February 6th, being familiar with class actions, the class certification battle is the most important fight in these types of cases. John coming in here in this capacity is a real kick in the balls to plaintiff's counsel. And I don't disagree with John, but the ball kick cannot be overstated. Gotta love that. Well stated, Attorney Rispoli. I absolutely love that. So even so, unfortunately, getting the news today, and technically this came down, I think it was June 30th, and then the news broke technically 2 days ago, and it wasn't until yesterday that this information began getting to any degree widely circulated. And here you can see this is a brand new article from today, so it takes news to kind of get out. But let's run through some of this. I'm going to share with you the perspective from, like I said, the several attorneys within the XRP community, what they had to say about this. But here is a piece from Bloomberg Law titled Ripple Labs Crypto Investors Get Class Status in Security Suit. A Ripple Labs Inc. investor class was granted certification in a cryptocurrency securities lawsuit against the company over virtual token losses. The company, CEO Bradley Garlinghouse and its subsidiary XRP2, challenged the certification, but the class met the 4 requirements for certification. Judge Phyllis J. Hamilton of the U.S. District Court for the Northern District of California said June 30th. And so I'll pause and note again, just to be super duper clear, this is just the class certification. This isn't ruling in favor of the plaintiff in any sort of way in terms of coming to a conclusion. We're not there yet. It having to do with whether or not Ripple actually broke the law. It's just there is now a class certification, and so things go forward now. But anyway, piece continues. The action alleges a scheme by defendants to raise hundreds of millions of dollars through sales of XRP and unregistered security to retail investors in violation of the registration provisions of federal and state securities laws, court records show. The plaintiffs established that common class issues will predominate over individual ones, the judge said. Now, Ripple argued that the plaintiffs failed to demonstrate they'd adequately protect the interests of the class, because many proposed members didn't agree on the premise of the lawsuit, and one named plaintiff, Bradley Sostak, made secondary market purchases, rendering his claims subject to unique defenses. And isn't that interesting too? Think about this. You buy XRP from somebody who isn't Ripple, and then you blame Ripple for stuff. Because reasons, folks. As always, because reasons. So here's what Attorney John Deaton had to say on this. This class action is the least of Ripple's worries. In fact, the plaintiff's attorney should be hoping the SEC loses and Ripple wins. If the SEC were to get a total victory, the SEC would be the one to collect the money and set up a fund to pay XRP holders, thus getting this class action. If Ripple wins, the judge is likely to follow Judge Torres' decision. So isn't it kind of funny to think? If the SEC gets their way, this isn't good for the plaintiff in the Zakhanov case, if the SEC wins. And I'll say this too, even if something silly happens and XRP holders for during the time period cited, which was some point in 2017 through, I think, June 30th, 2023, even if I were ever to be eligible for any sort of monetary gains as a result of something like that going through, I would never participate because I just find it ethically reprehensible. I mean, the Zakhanov guy, if he's the one that I'm thinking of, and it could have been Sostak, but or could be, there's another guy, Ryan Coffey. Well, at least one of them, though, if not more than one of them, held XRP for something like 2 weeks near the time of the all-time high, and then they sold at a loss. So it's just the credulity of this. Can you imagine? Can you state with a straight face that you're relying on the efforts of Ripples, and you give them 2 weeks' time to run a business that would impact, in theory, the price of XRP? It's the most bogus BS nonsense. So anyway, I'm just saying I would never participate in this chance, even if there is a potential monetary gain for me. Absolutely not. I find it disgusting. Somebody named Less Short XRP wrote to Attorney Deaton in response and said, John, how does all this affect us UK holders? What if there's some form of compensation? How can they differentiate? Attorney Deaton wrote, class certifications happen routinely. Here, the plaintiffs were asking for a worldwide class action. UK XRP holders, but in the UK, the Financial Conduct Authority said XRP is not a security. Same in Japan, Singapore, UAE, etc. It only applies to U.S. investors, but again, this case is simple compared to the SEC one. Yeah, so even though they were looking for worldwide class certification, it is just for the United States. And it's hard to believe that this could actually go anywhere beyond this. In terms of them actually winning and Ripple having to pay, it's just the idea of it is so absurd. Here's what Attorney Hogan had to say in response to this. Class certification just means the judge thinks there will be enough plaintiffs that all the claims should be kinda lumped together. It's really a no-brainer here. But it has no effect on the SEC case whatsoever. I am curious how the SEC case will affect the class action, though. Yeah, and also I'll say this. I think part of the judge's thinking also is that for people like me and pretty much all of you listening, about 100% of you listening, actually, if you're listening to this channel, it's probably 100% of you. If if you feel the same as me about XRP not being a security issued by Ripple or any of that crap, I think the judge's understanding is, well, no one's forcing you to take any sort of compensation or participate in that way. So I suppose that's what the thinking is in sort of justifying this. But either way, it still sounds silly because this class that wants to represent me and you and everyone else that holds XRP, they do not represent our interests. Absolutely not. Attorney Bill Morgan wrote to Attorney Hogan, and he said, given res judicata, actually, yeah, I had to Google this one. I'd seen the term before, I hadn't committed it to memory, so I quickly Googled it. And res judicata is described here as a matter that has been adjudicated by a competent court and may not be pursued further by the same parties. And so Attorney Morgan says, given res judicata on substantive issues only applies to the same parties in different proceedings and leaving aside the persuasive influence of Torres's deciding first, we could see the curious result of different findings on the issue of whether Ripple sold or offered securities. Yeah, that would be interesting and stupid as hell, but can you imagine two different courts coming to two different decisions on whether or not Ripple did the thing? What a world we live in here. Then we also had Attorney Fred Rispoli, and he wrote the following. Haven't read the order and article behind paywall, but bad news for Ripple for sure. Never good for a company when a class is certified. However, considering it's going the distance with SEC, it would seem the same strategy would apply here. In this case, next step is summary judgment, so it is behind the pace of the SEC case. On a more important level, I need to do more research on what happens if XRP ruled not a security in New York, but is a security in this Oakland case. Attorney Mark Fagel, what happens here? Any res judicata? And now we know what res judicata is. And Attorney Fagel is a former SEC attorney, and he did respond to Attorney Rispoli. And he talked about collateral estoppel. And I didn't remember what that one was either, so having the sum of all human knowledge at my fingertips, thanks to the Googles and the Webernets, I was able to look that up, and it's on your screen right here. A collateral estoppel is a doctrine that states that if an issue has already been litigated, it cannot be litigated again. So it kind of sounds like similar to res judicata, frankly. And then they wrote also, this means that a criminal or civil case cannot be taken to court twice. So Attorney Fagel responded and said, yeah, too long since I took Civ Pro. But if Ripple succeeds against the SEC, I assume the class plaintiffs would argue no collateral estoppel because they weren't a party to the SEC case. Though even without binding legal effect, it would presumably influence the California court's decision. Yeah, and I think that'll be the case regardless with a lot of happenings in crypto, really. But even though a lot of this stuff, these decisions on lower courts is not legally binding, it's not actually technically setting precedent, it can still be persuasive. And so it will still influence other judges. So in this case, it'd be good. If things go well for Ripple in the SEC v. Ripple case, then yup, better believe it. So that's where we're at. It's all a bunch of silly nonsense. I'll stop here, though. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.